Thank you for joining us tonight, Lila. I'm going to put the presentation over to you and Gigan, and thank you very much for joining us, and we'll leave it off for you.
Great, thank you so much. And thank you for inviting us to speak about this really important topic to our communities or to your communities. Well, thank you everyone for joining us this evening. So as Shauna had mentioned, we are here to talk about the duty to accommodate in the workplace and your right to gain disability-related accommodations at your workplace. So to start things off, today we'll be first give you a brief introduction about who we are. Who is Arch Disability Law Center? For those of you who may not know about us. And then we'll get into what are the human rights laws that apply, and what are your rights under these laws. And then we'll really get into explaining or exploring different either types of accommodations at work or and how to advocate to get these your accommodations when you are employed. And finally, we'll give you just a brief rundown of some practical tips for you to kind of take away from today's presentation. And at the end of it, we'll have some time for questions as well. So, before we talk about the law and your rights, I will turn it over to Gagan, who is a law student that is currently working at Arch, who will talk to you a bit about who Arch is and what we do.
Thank you, Lila. In terms of Arch, it's governed by a volunteer board of directors. Arch's bylaws ensure that the majority of directors identify as having a disability. It's a disability rights legal clinic located in Toronto, Ontario. Um, some of the Arch services specifically are free and confidential. They provide Arch provides summary advice and referral programs to persons with disability in Ontario and lawyers, paralegals, or disability-related legal matters. Arch is dedicated to defending and advancing the equality rights, entitlements, fundamental freedoms, and inclusion of low-income persons with disability across Ontario. Um, the representation of individuals or of disability-related organizations in test cases litigation is something that Arch does as well. The other part that also to mention is public legal education presentations such as this one is something that Arch is also involved in. And the last thing would be, and not least, is law reform. And I'd just like to talk the next about the areas of practice. There's quite a few here, as you could see on the next slide. First one would be accessibility laws, attendant, PSW services, education law, so that can involve school boards at the school board level, transportation, so that can include TTC, even in the GTA, of course, as well, anywhere in Ontario, really, with respect to transportation, and then discrimination and human rights, which is applicable at the workplace as well, and decision-making rights. So that's everything I could say at this point with respect to what Arch is all about. If you'd like to get any further details, you're welcome to look at online on our website is www.archdisabilitylaw.ca, where you can find more information about what Arch does. And I'll hand it off back to Lila.
Great, thank you so much again. So now let's get into the really substance of today's presentation. So what are the laws that apply here? Um, so before I really get into the different kinds of laws, I do want to just specify that because Arch We are in Ontario. We practice in Ontario. Most of the information I do have applies mainly in Ontario in terms of provincial laws, and I'll explain the difference. But there are also federal laws that could apply in some situations to offer some protections to persons with disabilities in some federal types of workplaces. And we'll go through the differences in the next couple of slides. But I just want to make that specification because I will be talking a lot about federal laws and provincial law, mainly Ontario laws. But if you are currently in a different province, there may be other provincial laws that would apply in your case. So, as I mentioned, there are several laws in Canada that offer different kinds of protections to persons with disabilities. And the difference between a federal law and a provincial law, whether that's Ontario, Manitoba, Quebec, Saskatchewan, whichever province, is really comes down to um, whether it's a workplace that is a what we call a federal workplace or one that is a provincial workplace. So the difference between those two, it would not necessarily be advertised that this is federal and this is provincial necessarily, but there are certain categories across the country that businesses or agencies or workplaces fall under. Um, so many of, at least for the Ontario laws and the federal laws, many of it is very similar in terms of what protections that they offer. At the federal level, for federal businesses, we're talking about the Canadian Human Rights Act and the Accessible Canada Act. Whereas and in Ontario specifically, we're talking about the Ontario Human Rights Code and the Accessibility for Ontarians with Disabilities Act. Now, if you are in a different province, there may be other laws that would apply for any provincial workplaces. And for those, I would suggest that you speak with a lawyer in your province to know exactly those laws. But we'll focus more on general protections and general rights during this presentation. So the Canadian Human Rights Act, which applies to federal agencies or federal workplaces, which means that it applies no matter which province you're in. If it's a federal workplace, then it applies to you. And those are businesses and agencies that the federal government has control over or power over. So, for example, banks. Banks is what we call federally regulated, which means that the laws that apply to a bank in Ontario is the same law that will apply to a bank in British Columbia, because banks are under the control of the federal government and not the provincial governments. There's also Canada Post as another example, airlines, Via Rail, telephone companies, Service Canada. These are just very some examples of what will be under the control of the federal government and be under the Canadian Human Rights Act. So if you work at any of these places or are applying for any job at any of these places, then you would be have some protections under the Canadian Human Rights Act. Whereas provincial legislation, such as in Ontario, like the Human Rights Code, those apply to businesses and agencies that the provincial government has power over. So basically, we're talking about stores, restaurants. In Ontario, we have Service Ontario, schools, community centers, city transportation, like city buses and things like that, provincial government departments, and other types of workplaces like that. So it's it's just a matter of, whether your workplace falls under the Canadian Human Rights Act or a provincial legislation, it comes down basically to what to do or where to go if you have a complaint, right, against your employer, right? Is it a complaint that you're making under a federal law, or is it one that you make under a provincial law? And that would then determine where you would file that complaint. But essentially, it is very much, very similar types of protections that you would have under one law or the other. And of course, at the federal level, there's also the Accessible Canada Act that comes into play that could apply as well. And the Accessible Canada Act applies really just to federal agencies or federal workplaces or federal, yeah, workplaces or companies, I should say. And that's more of a proactive measure that companies or agencies at the federal level have to take in order to be more accessible to others, including their employees. So to make their workplaces more accessible. In Ontario, we also have a provincial version of that accessibility legislation, which is called the Accessibility for Ontarians with Disabilities Act, where again, it's really more of a proactive measure for provincial workplaces to take so that their workplaces are more accessible to employees. However, when it comes down to your right to get accommodated, and your right to not experience discrimination, those really come from the human rights laws, which the federal level, we have the Canadian Human Rights Act, and there's provincial legislations as well. That really, in Ontario, would be the Human Rights Code. So these human rights laws, they really prohibit discrimination against a person based on a protected ground in a protected social area. So it's not just about employment, right? So we have for example, the Canadian Human Rights Act, many different protected grounds. We have disability, race, sex, family status, etc. And what would be referred to as a protected social area means in which area is there protection for the person. We have generally employment, services or access to services, housing, use of contracts, etc. So all these, really boils down to these human rights laws essentially dictate certain areas of day-to-day life where people are protected against discrimination based on one of the grounds that is listed in the acts. But today we'll be really just focusing only on the protected ground of disability, and we will be focusing on how that translates in the social area of employment. But just so you know that there are many other social areas and as well other protected grounds that exist in these human rights laws. So, just to start off with the basics, every person has the right to equal treatment in employment without discrimination based on their disability. That is the basic premise that we need to that we would start with, and that's where the laws start off with in terms of the protection that is afforded. And protection from discrimination and equal treatment that occurs in all stages of the employment relationship and for all kind of jobs. And what I mean by all stages of employment, it's not just about protection when you are employed. It's it goes beyond that. The human rights laws protect people from discrimination from the point of even applying for the actual job. It also applies when you are going through the interview process. And of course, it applies while you're working on the job. It would apply, that protection would also apply when you are returning to work after a time off, either for a disability-related reason or other reason. Um, and it would even apply as well to have some protection if ever there is a situation where you are terminated from that employment, right? It has to be for a reason that is not discriminatory. And when I talk about all kinds of jobs, it's not just full time. It doesn't have to be full time, doesn't have to be a permanent job. This protection applies even when you are part-time, in a volunteer position, on contract, or in any other situation. It's not just limited to full-time or permanent or even temp. It also applies when you're temporary, if it's a temporary position. And beyond the protection from discrimination, there's also a right through these human rights laws to protections from harassment based on disability at your workplace from either your employer or other employees. And as also stated in the human rights laws. So I mentioned the term disability several times, and of course this is a topic. But there is, a question sometimes that we get often from clients as to whether or not their disability would quote unquote qualify as being a disability under the human rights laws. Um, and a lot of it, I think, maybe comes from the fact that some programs or other services may not qualify a person as having a disability, whereas sometimes they do qualify, sometimes they don't. But it's important to remember that the word disability has in the law, in different laws, they have different definitions. And it depends really on the specific law that applies. So a sometimes there are some programs, for example, the CPP disability program may have a different definition of what would be qualify as a disability under their program versus uh, in Ontario we have the Ontario Disability Support Program, which has a very different definition as well of disability. However, in human rights laws, they have adopted a very large definition of disability. So they really, widen that gap, not as restrictive as many other programs or other laws. And that could sometimes create some confusion with employers who may say, well, if you don't qualify um, for this program or that program, then you don't have a disability, so why would I even accommodate? But the fact of the matter is that human rights laws are very, very large and open with what is a disability. Essentially, what they say is that a disability includes physical disability, mental health disability, developmental disability, intellectual disability, learning disability, visual disability, and hearing disability. So it can be very, very, it is very, very large for as a definition. And there's no need to prove that necessarily that the disability is permanent or has been going on for a certain amount of years or any of that. Um, and it may be, as well, it may be as well, including, and this may sound a bit strange, but a situation where, there's a presumption of a disability, right? If they presume that someone has a disability, or they believe that they're going to have a disability, then that might also, and they discriminate the employee because they believe that that employee may have a disability now or in the future, what we call a presumed disability. That may also fall under the category of protected ground of disability under human rights laws, and then and still that employee would also be protected from discrimination in that way, right? So this is a bit of a more rare situation where that happens, but I think it's good to know just in case, some people may have that kind of situation occur. And I think I just talked about this of a more presumed or perceived disability that's also included in the definition. And I'm just going to repeat again, just very quickly, but as I just mentioned, is when this is a perceived disability is when you think someone has a disability or your employer thinks an employee has a disability, whether or not they actually do, right? So, give an example. Again, I think I just talked about this, but a person could be discriminated against because others think they will have a disability in the future, or a person who uses an assistive communication device is presumed to have an intellectual disability, whether or not, they may not have an intellectual disability, but people perceive it and then they treat them differently because of that, because of their presumption. So that would also fall under the protections under human rights laws. So um, I talked a lot about discrimination, the word discrimination. But what exactly does that mean? Um, so generally, discrimination happens when you are treated differently because you have a disability. And the second point is very important as well, that different treatment has a negative effect on you. So this is very important to really keep in mind in terms of figuring out if you are experiencing discrimination or not, because it's not always direct. And we'll talk a bit more about that in the next slide. So of course, discrimination can be direct. It can also be indirect. Direct discrimination is really when it's clear from the facts that discrimination occurred. Your employer tells you you are fired because you have a disability. Cannot get more clear than that. Um, but that's, to be honest, pretty rare that employers are that upfront um, about it. So a lot of times, or what's more common, is indirect discrimination. And that's discrimination that's a bit less obvious, right, when you're looking at a situation. Um, but if you really analyze or look into exactly what happened, what are the facts, you would realize that actually I was being treated differently because of my disability. Um, and this could include rules and policies that the employer has that may seem to apply equally to everyone. Doesn't look like there's anything wrong with the policy, but in reality, that policy has a negative effect on certain groups or certain people with disabilities. For example, um, I could think of a very direct example, I guess, of an indirect discrimination. Is there's a policy of no dogs allowed in the workplace. doesn't seem like it would be discriminatory on its face. Looks like it applies equally to everybody. However, that general strict policy of no dogs allowed would be discriminatory to or would have a negative effect on employees who are using either a guide dog or a service dog, right? Who need to have either a guide dog or service dog at the workplace. And if they use this policy strictly, then that would become discriminatory for certain people with disabilities who use guide dogs or service dogs. Um, a more maybe less obvious type of discrimination as well, which is not necessarily based on a policy or a rule, but in a different situation. Um, so uh, having an employer assume that an employee with disability is incapable of completing work on time with no evidence that of their performance or anything like that, but it's just an assumption that they're making. And so the employer then decides to assign the most important projects to someone else because they assume that the employee with disability will not be able to complete it. That's also another kind of example of indirect discrimination. And it may seem direct, but I can probably assure that the employer is not going to directly say it, right? So it really is going to be, well, this employee never gets, always gets passed over for any of the big projects. Why? Then you have to do a little bit of digging to really realize or find out that the reason behind it is actually that the employer is discriminating against the employee. Um, when it comes to direct discrimination, I think I just gave one example, but could also be a policy that is very direct that says, someone with a mental health disability cannot work there, right? Or cannot do the job, for example. So that's really direct discrimination. So in order to ensure that an employee with disability or a person with disability is able to access either a workplace or access, a job application or or apply for a job or continue working throughout without experiencing discrimination. What needs to happen is there usually has to be some form of accommodations that relate to disability related needs. So an accommodation is something that is necessary essentially to put in place to avoid discrimination of a person in a given situation. That's a very general definition, but I think it's helpful to keep that to go back to the basic of what an accommodation really is. But in other words, it means, that the employer in an employment situation, the employer would be taking steps to eliminate any disadvantages or barriers that exist for either their employee with disability or their candidate that's applying for the job, right? And these barriers or disadvantage may be from rules, maybe from practices or policies, maybe from the environment that has been existing at that workplace that is really placing those barriers so that the person with disability is not able to access, the workforce or the workplace because of those barriers. So we could talk about, physical barriers, such as inaccessible buildings, technologies that are being used at the workplace, the actual workspaces itself could be presenting some physical barriers for employees. There are also non-physical barriers that exist, such as attitudinal barriers, right? So having that other employees or even the employers themselves, have this attitude or this ableist attitude about disability, and that really, brings forward like more of the stigma and really stopping persons with disabilities to actually have access or be able to be employed and work at those for employers like that. Other non-physical barriers that could exist would be workplace rules, or even job qualifications that are advertised as being absolutely essential for the um, for the job, but really are not necessarily essential for that job. And probably one of the most important points when we were talking about accommodations is that accommodations are based on the individual needs of the person with disability. What this means is that there is no one size fits all for accommodations when it comes to accommodations. One person may need a specific type of accommodation because of their disability related needs, and the next person that has may have the same disability but may have completely different individual needs. So the employer has to really work through accommodating their employee or candidate based on their specific needs. And we'll go through in the next few slides about how can the employer get that, evaluate that, and put in place the most appropriate accommodations for the person that is requesting it. There is this accommodation process that has to take place throughout, and that's really what we'll focus on for the next few minutes. And the thing with really that is the accommodation process is really where either, there are a lot of misconceptions from employers about what they need to do, what they're allowed to do, but also there are a lot of rights and responsibilities that both parties, so meaning the employee or candidate with disability and the employer have throughout the accommodation process in order to really find what is the most appropriate accommodations that needs to be in place. So, under human rights law, we're really talking about what we call a duty to accommodate. And that's duty to accommodate is a legal obligation from the employers. So it's really the employers that have this legal obligation to accommodate their employees and any candidates with disability that is applying for a job. Um, so most of the time now, and I'm gonna really say this like that, it's generally the way that it would be triggered is that the person with disability would need to inform inform the employer that they have an accommodation request, right? Or that they need a disability related accommodation. So once the employer learns that the person with disability has is requesting an accommodation, they have, first off, the obligation, first and foremost, to listen to the request for accommodation and then work cooperatively with the person to find a solution, meaning to find what is the accommodation that meets their needs. So, what I mean by this, and we'll go a bit more in detail in the next few slides, but just right now, what I mean by this is that the person with disability, when have generally the obligation to at least inform the employer that they need accommodations. Does not That does not necessarily mean that the person has to tell the employer what exactly is the accommodation they need, right? Because throughout the legal obligation of an employer, the employer um, has the responsibility to try to figure out um, what is the appropriate accommodation that would work in this situation. Now, they would work with you or as a person with disability to try to figure that out because, as I mentioned earlier, it is driven by your needs, right? The disability related needs, the individual needs. So the employer will need to work with the person with disability in order to figure out what the needs are. And then from there, try to figure out, okay, well, these are the needs. These are what the accommodations that could work here to meet those needs. The person with disability can, of course, make suggestions, right? And tell the employer, like, listen, this is what would work, which is great, but it's not your responsibility as the person with disability to automatically always find a solution. And I want to stress that because um, there are situations where maybe your employer would say, well, if you need accommodations, okay, well, then you tell me what it is. And you may know, but in situations where you don't know what it is that would work as an accommodation, whether because it's a new workplace, a new environment, or it's something, that you're not entirely sure of what would be possible or anything like that. You know, the employer cannot put that on your shoulder, right? They can't necessarily make you do all that work, to find the accommodation. But you kind of work together as a team, basically. And then the other thing I should mention about their legal duty to accommodate is that it is an obligation to accommodate the employees' disability-related needs to the point of undue hardship. Um, and we'll talk a bit later on about what undue hardship means, but it is one of the basic legal limit to an employer's duty to accommodate their employees. So, just like there's protections for persons with disabilities against discrimination at all stages of employment, employers also have a duty to accommodate during all stages of employment. Meaning, if you are trying to apply for a job or you're going for an interview for a job and you need accommodations for the interview process or for the application process, then you need to let them know about that, let the employer know that you have accommodation needs, and they would have a duty to accommodate you at that stage in order for you to either apply for the job or attend the interview or participate in the interview. And it goes the same for during the time of employment and at termination as well. So this protection or these rights also includes the right to access equal opportunities, which would fall under their obligation to accommodate the employee during in order to access those equal opportunities. if there's any training that is available during at work, or any performance evaluations, all that, there is protections for persons with disabilities to have access to equal opportunities in all those situations, um, while, they are being fully accommodated for their disability related needs. And I did talk a bit about this earlier, so I won't take too long over this point, but just a reminder, as the protections for against discrimination applies to all kinds of employment relationships, so does the duty to accommodate. So it's not just for people with permanent jobs or full-time work. Also applies if you are working on a temporary basis for the employer. If you're doing part-time work, volunteer positions, the employer always has a duty to accommodate you. And if you need accommodations during those time that you are working for them, then the legal obligation applies. So really want to get into here the accommodation process itself. Now that we have really determined, what is the duty to accommodate of an employer, there is once that is started, once the employer is aware that the person needs an accommodation, then there is what we call an accommodation process that gets started or gets triggered. Um, and this generally involves several people. Of course, the person with disability, the employer, and if it's a unionized position, if the person is unionized, the union will also be involved in that process. So, as I mentioned earlier, the process usually starts with the employee or the person informing the employer that they need an accommodation. Now, however, there are situations where the employer may have an obligation to accommodate, even if the employee has not said anything about it. So, this is a situation what we call the duty to inquire. This is where the employer may suspect or think that their employee with disability may have some accommodation needs. And then the employer would then have the obligation to just ask the employee if they need any accommodations, basically. And that's what we call, about duty to inquire. But most of the time, it really starts with the employee kind of really telling the employer about their need for an accommodation. Um, so once the process is started, everyone that is involved, so the employee, the employer, the union maybe, they really become part of a team here, and they must collaborate together with different roles and responsibilities, but they must collaborate and work together in order to identify the most appropriate accommodation for the employee. Um, so it's really a team effort, but really important, and I mentioned this earlier, but I think it's worth repeating. The person with a disability does not have the obligation to come up with a specific accommodation. So it's not up to them to decide what it is the accommodation will be. In other words, the employer cannot just throw that back to the employee and say, well, you say you need accommodations, then you go figure out what you need and then come back to me and I'll decide if we give it or not. The employer is actually the one that needs to do the investigating and the figuring it out while working with the employee themselves. Now, during the accommodation process, the person with a disability cannot expect necessarily a perfect accommodation either, right? So, we're really talking not about perfect accommodation, but appropriate accommodation. And that is one that respects the person's dignity, meets their disability-related needs, ensures confidentiality, and allows for the person to completely participate at work. Um, so it's not necessarily the perfect option, as long as the accommodation that's provided meets these other meets the disability related needs, respects dignity, and ensures confidentiality, etc., then that would be considered that the employer has fulfilled its duty to accommodate. Now, there may be situations where the most appropriate accommodation is not possible for whatever reason. But if there is one accommodation that would be put in place is not possible, um, then what the employer then has to do is try to see if there is an alternative accommodation to be put in place instead that would still also respect dignity, meet the disability-related needs, ensure confidentiality, and allow for complete participation at work. So some examples of what kinds of accommodations we could generally see at work. And before I go through the list, I do want to start off by saying these are just examples and not necessarily um, the only options for accommodations that are possible, but just what we most commonly see, I guess, if I should say it that way. And some of these things you may not think of it as an accommodation, but actually they actually are. Different start or end time of your shift, for example. That could be an accommodation for due to disability. Extra breaks during your shift. Um, Specific equipment for your workspace. You could look at standing desks, ergonomic chairs, adaptive technology, screen readers. Another type of accessible workstation in general. Use of a service animal in the workplace. Accessible format of documents available to you so that you can review the documents in an accessible way. And in some situations, the use of an attendant in the workplace as well. Now, for any of these examples or any other types of accommodations, there are specific, analysis of whether it's an appropriate accommodation, whether it's something that is possible in the workplace. And it's very individualized from workplace to workplace, from person to person, from job to job, right? So it's wouldn't be able today to tell you, oh yes, a use of a service animal is always something that could be accommodated in every single workplace in any situation. That's not necessarily true because there's a lot of factors that could come in place. I'm just using that as one of the examples, but just so you get an idea of it. Now, throughout the accommodation process, you generally do not have to even share your diagnosis with your employer when you're asking for accommodations. Most of the time, they don't need to know what the actual diagnosis is. What they do need to know is what the disability related needs are. Not what the disability is, but what the needs are in order to accommodate you. So your employer is not generally allowed to ask for a diagnosis, but they are allowed to ask for relevant information about your disability related needs. And I say generally because there are situations where you do have to disclose a diagnosis if it's required in order to get the accommodation, right? If there's funding attached to the accommodation that is only available to people with a specific type of disability, and you have to provide proof of that. In those situations, yes, they could ask for they could request or require your diagnosis. But generally speaking, you do not need to be sharing that piece of information. Um, Now, when we talk about information about disability-related needs, some of that kind of information that may be important to share would be notes from your doctor explaining your abilities, needs, and limitations at work, right? It's not for every single situation in your daily activities, but really focusing on abilities, needs, or limitations in the workplace. So, any request for more information from the employer, in order to gather more information about your needs, they must be reasonable and they must not be requests that are threatening or excessive to the point of causing a burden on you. And what I mean by that is that the employer cannot be asking for so much information that's no longer reasonable. It's just to, in a way, tire you out of your request for accommodations. But it has to be really strictly related to what is needed in order to grant the accommodation. Your employer must also keep your accommodation request and any supporting documents that you give them strictly confidential. Um, the only time that it could talk about that your employer could tell someone else at work about your accommodation itself is strictly on a need to know basis. So, what really, in the sense of if that other person needs to be aware of the accommodation in order to implement the accommodation. So I could give maybe a quick example of what that would look like, meaning if your colleague that you're working on a big project on, they may need to, and they're the ones that are leading the project with you and scheduling all these meetings and such things like that. They may need, if you have a late start of your shift, may need to know that you do not schedule any meetings before 11 a.m., for example, if you don't start before 11 a.m. and they start at 9 a.m. They don't need to know why. They don't need to know all the details, but it's really a strictly limited information in order for the job to go to be to continue on and in order for the accommodation to be properly implemented at work. So I mentioned earlier that there are some limits to the duty to accommodate, including undue hardship. Um, and I did want to maybe spend a little bit of time, not too much time on it, but a little bit just so that you're aware that they exist. The first one or the big one is really undue hardship. So employers have an obligation um, to accommodate the employees up to the point of undue hardship, which undue hardship refers to maybe excessive cost or health and safety concerns. Um, and one thing, especially with cost, um, we hear a lot of employers saying, "Oh, that costs money. We can't do it. It's undue hardship. We can't afford it." And that's not really what undue hardship is under human rights laws. It goes even beyond that. So when we're talking about costs or health and safety concerns, we're talking about hardship that is so huge for the employer that they can't go around it, right? To minimize that hardship. Because the law does allow for employers or does say that employers will have some hardship. That is okay. It's expected. But it's only when it becomes undue. So, for example, an accommodating someone would cost them so much that the company will go bankrupt, basically. So it's not the same level of undue hardship for a mom and pop shop as it would be for a multi-million dollar company. Obviously, right? The cost evaluation would be a lot different. But that is a limit that the employers can have to their legal obligation to accommodate. However, even if there is an accommodation that actually really is undue hardship for the employer, that doesn't necessarily mean always that they no longer have the obligation to accommodate. What that means is that they have to try to figure out if there is another alternative accommodation that could be put in place that would still meet the needs, but not reach the point of undue hardship, not be as costly, or not raise health and safety concerns either. But again, that's on the employer to really do that kind of work. The other limit to the duty to accommodate is what we call the justified job requirement. So that's when, accommodating someone would render or would make a job requirement no longer available or no longer there for that person or would attack that job requirement. And for that reason, they may not be able to accommodate that person. For example, someone who, because of disability, they cannot drive, right? They're unable to drive. And the job itself is a driver, right? So that would be a justified job requirement where they cannot accommodate for that specific position. Now, if the employer says, well, this is a job requirement, so I can't accommodate you for this, they have to show that the requirement itself is connected to performing the job position, right? For example, driving, was put in place honestly in a good faith. Like they're not just making this up at the last minute. And that they cannot change that requirement for that job without causing the employer undue hardship. So it's very much intricate, connected to the position. So not all job requirements would fall under this category. Um, and it's really a case by case situation about whether or not they are allowed to put a limit to limit their obligation to accommodate under this for this reason. So just to recap some responsibilities from both the employers, and we'll also talk about the employees' responsibilities throughout the accommodation process. Um, so employers' responsibilities throughout the accommodation process is accept any requests for accommodations in good faith. So really if there's a request for accommodation and from the employer, they have to look at it. They need to take an active role in identifying possible appropriate accommodations that would be available for the employee. They must keep your information that you provide to them confidential. That includes medical information, that includes your request for accommodations, and any discussions that you have with them about that topic. And they can only limit any requests for more information to what is necessary if they need more information about your disability-related needs. They could consult with experts with your consent, of course, to better understand your needs, and to help them figure out what appropriate accommodations may be put in place. But of course, they would ask for your consent before doing that. Um, they need to grant requests for accommodations within a reasonable time, so not take too long. What is reasonable and what's not depends a lot on the specific situation. But they, essentially can't take their time to go through the accommodation process slowly. If they are asking for any notes or any more medical information, um, they do have the obligation to actually pay for those reports or doctor's notes if you are being charged by your doctor, because the employer is making that request, so they have the obligation to pay for it. They also have the obligation to pay for the cost of the actual accommodation, if any. They cannot, dock that from your pay or make you pay for it. It comes out of their pocket. It's the employer's responsibility to do that. And again, as I mentioned earlier, if a specific accommodation causes undue hardship, the employer has to look at alternative options, if any exist. As for the employee, um, they also have some responsibilities during the accommodation process itself. So, if you have disability related needs at work, you do have to let your employer know about that. As much as the employer has a duty to inquire, meaning the duty to ask about it, they're not necessarily mind readers either, right? So if you do have disability related needs or you need accommodations at work, then you have the responsibility to let them know. You also have, as an employee, the responsibility to participate in discussions with your employer to help figure out what accommodations are appropriate. So to work with your employer, to help them understand, what your needs are and what accommodations would be helpful. And if there's a request for relevant and necessary information from your employer, you do have the obligation to provide that information in order to help them understand your needs. And this is important, but it is limited, of course, to what is relevant, right? If your employer is asking for things that are not relevant, then of course at that point you could, have that discussion with the employer and say, well, you already have everything you need and there's nothing more to provide. So finally, I'm just gonna end this off tonight with some general practical tips for you, for when you are advocating, for yourself to get some accommodations at work. So it is always a good idea to make your request for accommodation in writing if possible, and keep a copy of that request for yourself in case, it gets lost or there's a claim that it was not provided. It's not essential to have it in writing, but it is a good practice to do that just because there's a record there. If you have any meetings with your employer, take notes, take your own notes separate from their notes, so that, again, in order to keep a record of of the process and what are the developments of your accommodation request, where it's going. Now, a good practical tip is to continue to collaborate reasonably with your employer during the process. And in the event that your employer refuses to accommodate you, a couple of things you could do. If you are part of a union at work, contact your union representative. They will be in a position to provide assistance or help. If you do not have a union and you are in Ontario, you are an Ontario resident, then you can contact Arch Disability Law Center. We could provide some summary legal advice on your situation. If you are not a resident in Ontario, then you could contact a human rights lawyer or an employment lawyer in your province as well to get some legal advice on
Lila,
what you could do next. Yes.
this is Shauna. We are running over time and we're
Oh,
gonna have to
yes.
wrap it up. Sorry.
That's okay. That's okay. My next slide was actually questions.